Once you have established jurisdiction, venue, and standing, you may already know which court is the right court for you to go into. But what courts are available? Well, if you're going into the state court, then you start at one of the trial courts. Maybe not though. If you have a small claim, you may want to go into the small claims court. And if you have a claim that's less than $5,000 or $10,000, and the exact amount varies now because California has mucked up their statute. It used to be very simple. It was $5,000 or less, you go into small claims court, but now it's a complex formula and you got to go look it up. But if you have just a few $1,000s to dispute, you can go down to the clerk of the court's office, and they'll give you a booklet that shows you how to file your own complaint, and you can drag the other party into court, and you can have a day in court that's something like you see on TV with Judge Judy. There'll be no jury there. No lawyers are allowed in small claims court. You present your case informally, and the other guy presents his case, and then the judge decides the case. So that is small claims court. And some state courts also have a court of limited jurisdiction. In California, we had the municipal court. We now call it the court of limited jurisdiction, and then it took cases of $25,000 or less. And then the main trial court for cases of what they call unlimited jurisdiction and unlimited amount of damages you can claim, that is in California called the Superior Court, and it's Superior Court of each county. So you'd go to the Placer County Superior Court. It's a state court. They get paid by the state, but it's within the county. If you don't like the decision that you get in the state trial court, you can appeal to the State Court of Appeals. We are in the 3rd District Court of Appeals here, and that is down in Sacramento. And if you don't like the decision that you get from the Court of Appeals, you can appeal to the State Supreme Court. And again, that's down in Sacramento. They have an impressive State Supreme Court building down there. At the federal court, if you get into the federal court, the trial court there is called the District Court. And our federal court is down in Sacramento, 501 I Street. Very impressive, incredibly expensive building. You ought to go down there and see it sometime. It's just an impressive place. But that is the District Court, and we are in the Eastern District of California. That is our federal judicial district. If you don't like the decision that you get at the federal trial court, you can appeal to the Federal Court of Appeals, and those are broken up into what they call circuits, different geographic areas. We are in the 9th Circuit Court of Appeals. You may have heard that mentioned in the TV news from time to time. And the West Coast area is the 9th Circuit Court of Appeals. Now in the federal court, once you get to the Court of Appeals, if you lose at the Court of Appeals, you're usually done. Can you appeal to the Supreme Court? Well, you can petition to be heard by the Supreme Court, but in most cases you cannot get into the Supreme Court. They only have those 9 Supreme Court justices up there, and they only take about 100 cases a year. So thousands of people petition to have their case heard as an appeal to the U.S. Supreme Court, and out of those thousands, only 100 get heard every year, about 100. And what happens is you submit a petition, a writ to have your case heard at the U.S. Supreme Court, and the judges review the facts of your case, and at least 4 of the U.S. Supreme Court justices have to vote that your case is significant enough that they should hear that. And then you get what's called a writ of certiorari, and you get to take your case to the U.S. Supreme Court. What they're looking for, the kinds of cases that get into the Supreme Court, are cases that resolve some kind of major constitutional or federal issue and will make new law, landmark type cases, not run-of-the-mill type cases. They're either looking for major landmark federal issues, or they're looking at cases where there is a conflict between state law and federal law, or there is a conflict in the decisions that have made by the different Court of Appeals circuits. So the Ninth Circuit Court of Appeals tends to be much more liberal than the East Coast courts of appeals like the Second Circuit. And many times they will take the same set of facts in different cases and they will decide a case exactly the opposite in the two different districts. Well, now it's difficult for anybody else to predict how their case is going to come out if they're in one of the other districts. And so the Supreme Court likes to take those kind of cases and resolve the conflict, and then we know this is the law of the land from now on. These cases get decided this way no matter which circuit they are in at the time. So those are the courts that are generally available and how the appellate system works. And then before we start our trial, we have to look at one last thing, which is alternative dispute resolution.